हा दरवाजा बंद करू. थोडं राहू दे. Namaskar, and once again, a very good evening to all. On behalf of Akhil Bhartiya Adhivakta Parishad Devgiri Prant, I extend warm and cordial welcome to all the participants for today's lecture in this important series designed for the preparation of district judge and judicial magistrate first class and civil judge junior division examinations. In yesterday's session, I had the privilege to giving a detailed introduction of our esteemed speaker. However, for the benefit of those aspirants who could not attend, I take this opportunity to briefly introduce him. Shri Sandeep Dnyanoba Munde sir is presently serving as a Deputy Registrar Group A at the Maharashtra Administrative Tribunal Mumbai bench at Aurangabad since January 2023. Notably, he secured the first rank in Maharashtra through MPSC for the prestigious post, which reflects his exceptional merit and dedication. He has completed his BSL, LLB, and LLM with first class from MP Law College, Sambhajinagar, specializing in constitutional law. Further adding to his academic accomplishment, he successfully cleared the SET examination in 2019. Before joining his current position from 2014 until his selection, he practiced law at the High Court of Bombay bench at Aurangabad under the guidance of Advocate Rahul Karpe and also appeared before the various tribunals. In addition to his professional achievements, Sir has made significant contribution to legal education. From 2020 to 2025, he has been actively teaching the subjects such as Civil Procedure Code, Administrative Law, and Jurisprudence, guiding numerous aspirants in their judicial career preparation. He has also qualified for the interviews for the post of Civil Judge Junior Division and Assistant Public Prosecutor, which further demonstrates his deep understanding and command over the legal subject. With this brief introduction, it is my honor and privilege to respectfully invite Sri Sandeep Munde sir to deliver his second lecture on a Civil Procedure Code. Thank you. Sir.
Thank you, sir. So in the last session, we have started to discuss that was the introductory lecture with regards to the Code of Civil Procedure, in which for our convenience, we divided the Code of Civil Procedure into 4 parts. That first part deals of the suits in general are from Order 1 to 20 and Section 1 to 35, which deals with regards to the basic proceeding of the Code of Civil Procedure, from the institution of the suit up to the passing of the judgment and decree by the court. Second part deals with regards to the execution of proceeding, that is the Order 21, wherein the 106 rules are there, and from Section 36 to 74, which deals with regards to from the filing of the execution application up to the satisfaction of the decree, up to the consent decree holder shall get the fruits of that decree. The third part, which we have discussed from the Section 75 to Section 95 and Order 22 to Order 40, which deals with regards to the miscellaneous provisions or the incidental proceedings or the special proceedings or a particular proceedings, from Order 22 to Order 40, and last part that deals with regards to from the Section 96 to the 113 or 115 and other provisions, and from Order 41 to 45 that are the appellate provisions. The party who is aggrieved with the decision of the judgment and the decree may approach to the court for the said purpose. Now we will discuss the particular things or by directly touching to the Code of Civil Procedure arrangement of the section. If we peruse the preliminary sections, that is from Section 1 to 8, particularly every act, every code deals with regards to the first section of the short title commencement at the extent. There will be the preliminary examination that when the Code of Civil Procedure came into the existence or commences, you have to keep in mind it shall come into force on the first day of January 1909. The second section deals with regards to the definition. If we see in the definition clause, what are the definitions? And if you peruse the earlier question papers of the preliminary examination, many times the question has been asked about the definition of decree. If we read the definition of decree, what is the definition of decree? Decree means the formal expression of an adjudication which, so far as regards the court expressing it, and conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of plaint and determination of any question within section 144, but shall not include. So the definition of decree is divided into three parts. First part deals with regards to the what is the concept of decree, which order, which expression will be considered as a decree. It is also stated that decree may be the preliminary or decree may be final. It is also stated that it shall deem to include which orders, or if there is the order passed with regards to the rejection of the plaint, it also includes the decree or any adjudication has been made under section 144 of the Code of Civil Procedure. It also includes the definition of decree. So, but it shall not include. The third part, last part states, it shall not include any adjudication from which an appeal lies as an appeal from an order. Concept of appeal from an order there in the order 43 and section 103, from which orders appeal from order will lie, that is the AO, appeal from order, or any order of dismissal for default. If any proceeding has been dismissed for default, in short, if any proceeding has been DID, will not be treated as a decree. Our first definition is the code include rules. If we peruse the subsection 18, it states rules means rules and forms contained in the first schedule are made under section 122 or section 125. In the last session itself, I have told you there are 51 orders in the Code of Civil Procedure, and out of in each and every order there are the rules. The third definition is the decree holder. Who may be treated as a decree holder? The person in whose favor a decree has been passed or an order capable of execution has been made. Again, the decree holder, there is the definition of judgment debtor. So the judgment debtor means the person against whom a decree has been passed or an order capable of execution has been made. So in the execution proceeding, there should be the two parties. One is the decree holder and another one is the judgment debtor. The another definitions that the district, local limits of the jurisdiction of the principal court of the original jurisdiction, foreign court and the foreign judgment. The courts which are not situated in India or and not established or continued by the authority of the central government, that are the foreign court, and any judgment given by the foreign court, that will be the foreign judgment. The seventh definition is the government pleader. The person who has been appointed by the government and who acts for the government, he will be the government pleader. Next definition is the India. Subsection 8 defines judge. Definition of judge. Judge means the presiding officer of a civil court. This is the definition given under the Code of Civil Procedure. Legal representative, as we all know, the person who in law represent the estate of the deceased person. On subsection 12, there is the concept of means profits. It is the only concept under the Code of Civil Procedure which defines means profit, means those profits which the person in wrongful possession of such a property actually received or might with ordinary diligence have received therefrom, together with interest on such profit, but shall not include profit due to the improvement made by the person in wrongful possession. You should trace on the wrongful possession to grab or to claim any profits which will be covered under the means profits, there is the essential element of the wrongful possession. If the concerned party in the wrongful possession and having knowledge with regards to it, then the definition of means profits will be useful and it is defined under subsection 12. We know the movable property include the growing crops. We have seen the definition of decree. Decree is the formal expression of an adjudication, conclusively determine the rights of the parties or any matter in controversy in the suit. It also includes the 144, adjudication made under 144, or the rejection of claim. But the 14th subsection 14 states order. Order means the formal expression of any decision of a civil court which is not a decree. Whenever whatever the order has been passed, which is not treated as a decree, that will be treated as an order. The definition of pleader means any person entitled to appear and plead for another in court and includes an advocate, vakil, or attorney of a high court. Prescribed means the prescribed by rules. Public officer, the definition of it includes every judge or the officers who has been appointed by the government and paying salary by the government. The other definitions are the rule sharing corporation and the sign. So, for the preliminary examination, definition clause play very important role in which one of the question can be asked with regards to the definition of decree or the decree holder or the judgment debtor or any of the definition. Now the section 3 of the subordination of the court. As we all are the practicing advocates, we know the subordination of the courts, that subordination of the courts in which it includes the Supreme Court, High Court, District Court, Civil Judge Senior Division, Civil Judge Junior Division, and the last one is the Court of Small Quantity. Just now we have seen the section 2, the definition clause. Some of the definitions which are the important terms under the Code of Civil Procedure, but which are not defined under section 2. For example, affidavit, which is there in the order 19. Then the appeal, there is no definition of appeal has been prescribed under the Code of Civil Procedure under section 2. But the appeal is the judicial examination of the decision by a higher court of the decision of an inferior court. Who will file the appeal? Appeal will always filed by the aggrieved party, and in the appellate court, we'll see the judicial examination of that decision rendered by the inferior. The most important thing under the Code of Civil Procedure to lodge or to file the suit is the cause of action. So there is no definition of the cause of action. What is meant by the cause of action? The cause of action, a bundle of essential facts which it is necessary for the plaintiff to prove before he can succeed. What is the cause of action? It is the duty of the plaintiff to show there is the cause of action to file the suit. The another thing with regards to the caveat which we lodge under section 148, no definition of civil under the Civil Procedure Code. Definition of court is not there. The court place where the justice is administered. Also, there is no definition of the plaintiff as well as defendant. So, who may be called as the plaintiff? Plaintiff, a person who brings a suit or commences an action against the defendant, he will be treated as a plaintiff. And who may be called as defendant? A person against whom a relief is claimed by a plaintiff. He may be called as a defendant. Then the definition of execution. The process of enforcing or giving effect to the judgment, decree, or the order of the court, that is the execution proceeding. The next term is the issue. That is the point in question. The issues are of three kinds. That is the issues of fact, issues of law, and the mixed issues of the fact and law. The another term, that is the jurisdiction. Jurisdiction is also not defined under the Code of Civil Procedure. Jurisdiction means an authority to decide. So, what is the plaint? It is the pleading of a Plaintiff, that is the statement of claim or a document or a memorial by the presentation of which suit is instituted. Next term, what is meant by the suit? Suit means the civil proceeding instituted by the presentation of a claim. Another thing is summons. What is meant by the summons? It is a document issued from an office of the Court of Justice calling upon the person to whom it is directed to attend before the judge or the officer of the court for a certain purpose. We have seen the plaint, it is the statement of plaintiff. But what is the definition of the written statement? Written statement is a reply of a defendant to the plaint filed by the plaintiff. So, these are the some of the terms in addition to the terms which are defined under section 2 of the Code of Civil Procedure. So the section 4 to 8 deals with regards to the saving clause, application of the code to the revenue courts, the provisional small causes court, and the precedency small causes court. Now, the part first of the Code of Civil Procedure, which is heading as a suits in general, in which the subtitle is the jurisdiction of the courts and res judicata. So, in the last lecture itself, I have told you the section 9 is the key statement of the Code of Civil Procedure, which opens the doors with regards to the jurisdiction of the courts. Section 9 states courts to try all civil suits unless barred. Why I have told you it is the key statement, or why it is the opening statement of the Code of Civil Procedure with regards to the jurisdiction of the civil court. The reason is that it states court to try all civil suit unless barred. What is the jurisdiction of the civil court? The court shall, subject to the provisions herein contained, herein means the contained in the Code of Civil Procedure, have jurisdiction to try. Have jurisdiction means the authority to decide, jurisdiction to try all suits of a civil nature. Full power, full authority to try all suits of a civil nature, excepting. What excepting? Suits of which their cognizance is either expressly or impliedly barred. At the first instance, power has been given to the civil court to try all kinds of suits of a civil nature. But under the exception, it has been carved out that if their cognizance has been expressly or impliedly barred, the court, civil court, has no jurisdiction to try it. I will give the example in the daily routine that the section 34 of Securitization and Reconstruction of the Financial Assets Act, what it states, section 34, civil court not to have a jurisdiction. There is the express bar. When we peruse the section 164 of the Cooperative, 163, sorry, section 163 of the Maharashtra Cooperative Societies Act 1960, what is the heading of 163? Bar of jurisdiction of the courts, same as expressly provided in this act, no civil or revenue court shall have any jurisdiction in respect of. If there is the registered cooperative society, jurisdiction has been expressly barred in view of section 163 of the Cooperative Societies Act. Same thing with regards to the Work Tribunal, section 85, bar of jurisdiction of the civil court. Same thing with regards to the Administrative Tribunal Act 1985, section 28, exclusion of jurisdiction of courts except the Supreme Court under Article 136 of the Constitution of India. Meaning thereby, section 9 states the civil court is having jurisdiction to try all suits of a civil nature except when their cognizance has been expressly or impliedly barred. I have given you the example in which manner it has been expressly or the impliedly barred. The next thing, what are the kinds of jurisdiction? That the first one is the territorial or local jurisdiction that we have to discuss from section 15, place of suing, jurisdiction of the civil courts. where to institute the suits. Every court has its own local or territorial limits beyond which it cannot exercise its jurisdiction. So, the court situated under the Chhatrapati Sambhajinagar, the property if situated under the Pathan jurisdiction, local or the territorial jurisdiction. The second one is the pecuniary jurisdiction, amount or the value of the subject matter of which does not exceed pecuniary limits. It is jurisdiction has also been decided on the pecuniary limits, amount or the valuation. It is different from junior division to senior division to the district court or to the high court. Jurisdiction as to the subject matter. What subject matter involves? Depends on the subject matter. The family court has jurisdiction to decide the matters dispute arising from the family dispute. That is the jurisdiction depends upon the subject matter. Original and appellate jurisdiction. The court is original jurisdiction as well as the appellate jurisdiction. So these are the themes with regards to the section 9 jurisdiction of the courts. Now section 10 9A was inserted by virtue of the Amendment Act of 61 of 2018 and in view of the judgment passed by the Supreme Court, it has been repealed. Section 10, Section 11 and Section 12. What it indicates? Section 10 is the stay of suit or it is also called as res sub judice. Section 11 is the res judicata and Section 12 is the bar to further suit. I will not take more time by reading all these provisions. I will give only the crux of these provisions and what is the importance of these provisions for the exam purposes. For the stay of suit, there will be the short notes. For the res judicata, there will be the short notes or the long question. And for section 12, there will be the short note. So why I am saying all the three things at the same time? For the stay of suit, the opening is in negative manner that no court shall proceed with the trial. There is expressly bar that the no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit. In this section 10, there is the two concepts that the previously instituted suit and subsequently instituted suit. If two suits are pending with regards to the same cause of action, claiming litigation under the same title, and if both the suits are pending in India, the court shall stay the suit which has been subsequently filed by the party. It is also stated for the how it will attract when the two suits are pending before the court of law with regards to the same issue between the same parties or claiming under the same title, two suits cannot be adjudicated at the same time. Therefore, the title is the stay of suit. Suit is required to be stay. Which suit? Then the subsequent suit will be required to be stay, and at the same time, it cannot be proceed. So, there has been expressly bar has been created. No court shall proceed. Court has no power to proceed with the suit if the two suits are pending between the same party. Now, we will further move to the section 11, res judicata. On the res judicata, many times the question has been asked for the long question for 10 marks and sometimes for the 4 marks or the 5 marks as a short note. Section 11, why there is the need to introduce or to enact the section 11? It states, no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit. See the difference in between 10 and 11. There in section 10, it has been stated no court shall proceed. And in the section 11, it has been stated, no court shall try any suit or the issue. So, it is clearly the bar has been created. Don't try the suit when the issue involved in directly and substantially is in the former suit between the same parties or between parties under whom they or any of them claim litigating under the same title, and if that decision has been given by the competent court of law, then there is the bar to file the suit, and no court shall try any such kind of suit. Why it is the need? Once the matter finally decided by the competent court, no party can be permitted to reopen it in the subsequent litigation. The theme of res judicata depends upon the maxim of ex captio res judicata, which means one suit and one decision is enough for any single dispute. For any single dispute, one suit and one decision is sufficient. What is the meaning of res and judicata? The res means the subject matter or the dispute, and judicata means which is adjudged, decided, or adjudicated by the court of law. So now there will be the thing that what are the objects of res judicata? The doctrine of res judicata depends upon three maxims. That the first one is the nemo debit bis vexari pro it idem causa, which means no man should be vexed twice for the same cause. As we know the principle of natural justice under the Constitution of India or under the Criminal Procedure Code earlier, for the one offense, the person cannot be punished twice. Or Article 20, Subarticle 2. Here, no man should be vexed twice for the same cause. Second maxim is the interest republic ut sit finis litium. So, it is in the interest of the state that there should be an end to the litigation. So, again and again, if once the decision has been given, you have to accept it. You may approach in the appeal, but you cannot harass the parties by filing again and again said suit against the same party. The third one, res judicata pro veritate occupator, a judicial decision must be accepted as a correct. These are the crux with regards to the res judicata. What are the conditions for the res judicata? That the matter directly and substantially in issue, that the former suit parties same title, such parties litigating under the same title in the former suit, the court which decided the former suit must have a competent to try the subsequent suit or when such issue is subsequently raised and heard and finally decided by the court in the former suit. So, it is also one of the important terms under the Code of Civil Procedure, that is the res judicata given under section 11. What is the section 12? It reads bar to further suit. Bar to further suit, where a plaintiff is precluded by rules from instituting a further suit in respect of any particular cause of action. With regards to the two words are important. Precluded by the rules from instituting a further suit. It is not only mentioned the suit. It has been stated instituting a further suit in respect of any particular cause of action. He shall not be entitled to institute a suit in respect of such cause of action in any court to which this code applies. So, bar to further suit, and what are the examples or under which provisions under the Code of Civil Procedure there has been bar? The first example of section 12 is the latest section 11. No court shall try. It is the bar. If earlier decision is there, you cannot institute the further suit. Therefore, there is the bar to institute the further suit. Section 11, res judicata. Thereafter, section 21A, objection to the jurisdiction, no further suit will lie. Then section 47(1), all the questions arising in the executing court needs to be decided by the executing court itself. No separate suit will lie. Then section 95(2), compensation for wrong. Section 144(2), restitution. Order 2, rule 2, party frame of suit, if any joinder of cause of action or any cause of action or any relief has not been sought on the basis of it, you have been precluded. Then order 9, rule 9, bar to further suit. Order 11, Rule 21, Sub Rule 2. Order 22, Rule 9, abatement. Order 22, Rule 1A. Order 32, Order 33, Rule 1.3. Order 23, Rule 3A. The Code of Civil Procedure precludes the plaintiff from instituting the suit in these cases. So, the section 13 and 14 deals with regards to the when foreign judgment not conclusive, in which cases it is not conclusive, when it has not been pronounced by the court of competent jurisdiction, when it has not been given on the merits of the case, or where it has been incorrect view of the international law, or which has been refusal or to recognize the law of India in cases in which such law is applicable, where the judgment was obtained or opposed to the natural justice, where it has been obtained by fraud, or where it sustains a claim founded on the breach of law in the course in India. In that contingencies, foreign judgment not conclusive. But in view of the section 14, there is the presumption as to the foreign judgments, and the word shall has been used. What it states, court shall presume upon the production of any document purporting to be the certified copy of a foreign judgment that such judgment was pronounced by the court of competent jurisdiction unless contrary appears on the record, but such presumption may be displaced by proving want of jurisdiction. If it covers under section 13, then it can be not presumed, but under section 14 it has been mentioned presumption as to the foreign judgments, and the court shall presume, word shall has been used, therefore it is the mandatory effect. Now moving further, the subtitle is the place of suing. It is kind of territorial jurisdiction or the local jurisdiction where to file the suit, where is the place of suing. Section 15 reads, court in which suit to be instituted. Section 9 states the civil court is having jurisdiction to try all suits of a civil nature unless the cognizance has been expressly or impliedly barred. It now states where to institute the suit. Section 15 reads, every suit shall be instituted in the court of the lowest grade competent to try. If I want to file the suit with regards to the recovery of 70,000 rupees, can I file the suit before the learned civil judge senior division or directly before the district court of the high court? No, because section 15 states every suit shall be instituted in the court of the lowest grade competent to try it. What is the reason behind it? You have no choice of filing of the suits. The jurisdiction has the power or the authority of the court to decide, and the consent never confer the jurisdiction. So if the valuation or the amount decide the pecuniary limits of the jurisdiction, and on the basis of pecuniary limits of the jurisdiction, you are required to file the suit in the court of the lowest grade competent to try it. Now the next thing is that I have already told you for filing or for the institution of the suit, 4 things are required. That there should be the parties, opposing parties, that the order one parties to the suit. There should be the subject matter in dispute. There should be the cause of action and reliefs claim. What are the kinds of properties? We know movable property, immovable property. So from section 16 to 18, deals with regards to suits to be instituted where subject matter should be. On the basis of subject matter, whether subject matter is the movable property, or if the subject matter is the movable property, or is the subject matter is any other property, and depending on these facts, section 16 to 18 deals with regards to the when the subject matter is the immovable property. 19 states when it is the movable or the wrong to the person, and 20 states if it is not covered from 16 to 19, then section 20 is there. Now we will see the section 16. Section 16 reads, suit to be instituted where subject matter situate. subject to the pecuniary. What is the word he has been used? Subject to the pecuniary or other limitations prescribed by any law, suits. Where subject matter situate. For the recovery of immovable property with or without rent or the profits. B. For the partition of the immovable property. C. For foreclosure, sale or redemption in case of mortgage off or charge upon the immovable property. D. Or the determination of any other right to or interest in the immovable property. E. For compensation for wrong to the immovable property. F. For the recovery of movable property actually under distraint or attachment. If you peruse from A to F, A to E, in each clause, immovable property word has been used. In the F, immovable property word is not there, but it has been stated actually under distraint or attachment. Shall be instituted. Where to institute if the subject matter pertains to the immovable property? Shall be instituted in the court within the local limits of whose jurisdiction the property is situated. Shall be instituted in the court within the local limits of whose jurisdiction property is situated. When the property is the immovable property, or suit for the recovery of immovable property, for the partition, for the foreclosure, for the sale, redemption, determination of rights, compensation to wrong to the immovable property, consider immovable property is situated at Python. According to the section 16, we have to file the suit in the court situated at Python. Python court is having competent jurisdiction to try the suit as the property, immovable property is situated under the jurisdiction of the Python. See the section 17. Suits for immovable property situate within jurisdiction of different courts. Now we are having more than one property. One property is situated at Python and another property is situated at Ambad district, Jalna. Or the property is situated at Gangapur. Where a suit is to be obtained relief respecting or compensation for wrong to the immovable property, situate within the jurisdiction of different courts. Situate within the jurisdiction of different courts. Python court is having different jurisdiction, Ambad court is having different jurisdiction, and Gangapur court is having different jurisdiction. The suits may be instituted in any court. Suits to be instituted in the any court within the local limits of whose jurisdiction any portion of the property is situated. In such a circumstances, all the three courts where the property portion is situated, all the courts is having jurisdiction to try. Next contingency is under section 18. Place of institution of the suit where local limits of the jurisdiction of the courts are uncertain. Our property is situated at the boundary of Python and Ambad Taluka. Our property is situated at the boundary of Gangapur and Kannad Taluka. And when the limits are uncertain, by making the statement in the said plane, you may institute the suit at any of the places where you are claiming the court is having jurisdiction to try it. Section 16 to 18 is for the immovable property. If the property is situated, immovable property, in which jurisdiction it is situated, that court is having jurisdiction. When there are more courts than one and the more properties are there, at any place in which court the property is situated. When the boundaries are uncertain, by making the statement to that effect at any of the court having jurisdiction to try it. Section 19 states the suits for compensation for wrong to the persons or the movables. Where a suit is for compensation for wrong done to the person or to the movable, if the wrong was done with the local limits of the jurisdiction of one court and the defendant resides or carries on business or personally works for gain within the local limits of the jurisdiction of another court, suit may be instituted at the option of the plaintiff in the either of the state court. Whenever the cause of action arises or where the defendant resides, at any places, the plaintiff is having option to file the suit at the places when there is a suit for compensation for the wrong to the persons or the movables. 16 to 18, 15 with regards to the lowest grade competent to try it, 16 to 18 with regards to the immovable property, 19 with regards to the wrongs to the person or the movables, section 20, other suits to be instituted where defendant resides or cause of action arises. Other suits. Suits which are not covered under section 16 to 19, where to institute that suits? It is stated in the section 20, it has to be instituted where the defendant resides or carries on business or personally works for gain, or B, at the same line, and the C, the cause of action wholly or in part arises. The plaintiff has to lodge the suit with regards to any other suits to be instituted where the defendant resides or cause of action arises. So, from section 15 to 20 with regards to the jurisdiction of the court. But being defendant, if you have an objection to the jurisdiction claimed by the plaintiff, can you raise the objection to the jurisdiction? Yes, according to the section 21, the clause states, the section 21 states with regards to the objection to the jurisdiction. No objection as to the place of suing shall be allowed by any appellate or revisional court unless such objection was taken in the court of the first instance. First instance at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement, and unless there has been a consequent failure of the justice. Where to lodge the objection? At which stage you are entitled to lodge the objection? If you have an objection with regards to the place of suing, you raise such objection at the first instance, meaning thereby before the first instance court, at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement of the issues, meaning thereby till order 14, framing of issues and settlement of issues, they are under order 14. Prior to the settlement of issues, as early as possible, at the first instance, you may lodge the objection to the place of filing, you may lodge the objection to the jurisdiction. If you not raise the such objection to the original court at the first instance, at the earliest opportunity, revisional court shall not allowed by any revisional or the appellate court unless there has been a consequent failure of the justice. That exception has been carved out. To the no objection as to the competence of the court with reference to the pecuniary limits of its jurisdiction shall be allowed. Same with regards to the pecuniary limits. And third, no objection as to the competence of the executing court with reference to the local limits of the jurisdiction shall be allowed. So, keep in mind, for raising any kind of objection, you have to raise the objection at the earliest possible opportunity, at the first instance, and at or before the settlement of the issue. Just prior to few minutes back, we have discussed bar to the further suit under section 12. What is the section 21A? 21A states bar on suit to set aside decree on objection as to place of suing. No suit shall lie challenging the validity of a decree passed in a former suit between the same parties or between the parties under whom they or any of them claim litigating under the same title on any ground based on an objection as to the place of suing. Therefore, whatever objection you want to raise, you have to raise in that suit only. And after that, when the decree has been passed, you cannot challenge that decree on the basis that that court is not having competent jurisdiction. 21A creates the bar on a suit to set aside the decree on objection as to the place of suing. So, now, the provisions from section 9 to section 20 with regards to the suits in general and the place of suing, in which we have discussed the section 9, the jurisdiction of the civil court. Civil court is having jurisdiction to try all civil suits of a civil nature. unless its cognizance has been expressly or impliedly barred. Section 10, res sub judice or the stay of suit. No court shall proceed to try if the issue has been already pending before the competent court of law. Section 11, res judicata, when there is the issue directly and substantially in issue and which has been decided in the former suit by the competent court, no court shall try any such suit. Then the section 12, bar to further suit. The bar to further suit examples are section 11 and section 21A and the others on which ground there is the bar has been created. Section 13 and 14 with regards to the foreign judgments and the presumption with regards to it. Section 15 to 20 with regards to the place of suing. 15, you have to lodge the suit, civil suit in the court of the lowest grade competent to try it. Section 16 to 18, when the property is the subject matter of the property is the immovable property. Section 16, where the property is situated. Section 17, where it has been situated under the different court jurisdiction. Both the courts is having jurisdiction. 18, when the boundaries are uncertain by making the statement. 19, when the wrong to the person or the movable property, it is depends upon the, it is the option to the plaintiff where the cause of action arises or where the defendant resides, and all other suits according to the section 20, which is not covered earlier, it can be at the option of the plaintiff where the cause of action arises or where the defendant resides, or according to the 20C, where the cause of action or part of cause of action arises. 21 with regards to the objection to the jurisdiction, and 21A with regards to the bar on suit to set aside the decree on objection as to the place of suing. Now, these are the intermediate provisions from section 22 to 25, which we will discuss in continuation. Section 22 states power of the transfer of suits which may be instituted in more than one court. Where the suit may be instituted in any one of two or more courts and is instituted in one of such courts, any defendant after notice to the other parties may at the earliest possible opportunity and in all cases where issues are settled at or before such settlement, apply to have the suit transferred to another court, and the court to which the application is made, after considering the objection of the other parties, if any, shall determine which in which the several courts having jurisdiction the suit shall proceed. Provisions from section 22 to 25 deals with regards to the transfer of the proceeding from one court to another. For transfer of the proceeding when there are more than one suits, there are two or more suits in which any of the defendant is the same party, maybe with regards to the same cause of action or the other cause of actions, or the parties are same. For the proper adjudication of the suits, any of the parties may apply that the concerned suits may be transferred at the proper places. To what court application lies? Order section 23 reads, to what court application lies where the several courts having jurisdiction under subordinate to the same appellate court, and application under section 22 shall be made to the appellate court. One suit is pending at Paitan, another suit is pending at Gangapur. Appellate authority principal district judge is the Chhatrapati Sambhajinagar. He may apply to the PDJ of the Chhatrapati Sambhajinagar if both the courts are situated under the appellate court. Second, 23(2), where such courts are subordinate to different appellate courts but the same high court, the application shall be made to the said high court. One suit is pending in the beat districts, another suit is pending in the Chhatrapati Sambhajinagar, you may approach to the high court for the transfer of the proceeding. 3, where such courts are subordinate to the different high courts, the application shall be made to the high courts within the local limits of jurisdiction the court which the suit is brought is situated. Maybe under the Nagpur or the High Court where the court is situated, you may file the application. There is one judgment on the miscellaneous civil application under section 24, general power and the transfer of the withdrawal power of the High Courts, wherein Justice Ambadas Joshi sir has delivered the judgment with regards to the competency of the court to High Court to transfer the proceeding of the civil nature which has been instituted in the jurisdiction of the different high courts, considering that Nagpur bench or the Aurangabad bench under the jurisdiction of the Bombay High Court. 24 deals with the general power of the transfer and the withdrawal with regards to the High Court or the District Court, and they may transfer any suit, appeal or other proceeding pending before it for the trial or disposal to any court subordinate to it and the competent to try or dispose of the same. It is also power to withdraw any suit or appeal or other proceedings pending in any court subordinate to it and try or dispose of the same, transfer the same for trial or disposal. And the same thing with regards to the power of the Supreme Court to transfer the suit under Section 25 when the suits are instituted under the different high courts under the different state. According to the latest amendment, the power has been vested with the Supreme Court by virtue of it has been inserted by the Amendment Act of 1976, which came into existence from 1st of February 1977. Supreme Court is having power to transfer the proceeding from one high court to another high court or from one state to another state. Now coming to the next point, or it is the topic with regards to the institution of suit. Now, up till now, until the section 25, we have only discussed from section 1 to 25, section part. We have not touched to the order part. But now, we have to discuss the sections as well as the simultaneously order part. Why? There is the heading, subheading with regards to the institution of suits. And section 26 reads institution of suits. Every suit shall be instituted by the presentation of a plaint or in such other manner as may be prescribed. 2. In every plaint, fact shall be proved by affidavit, provided that such affidavit shall be in the form and manner as prescribed under Order 6 of Rule 15A. What it is contemplated under section 26 deals with regards to the institution of the suit. I will tell you what are the essential things for the institution of suit. Order 14. What are the essential things for the institution of the suit? For the institution of the suit, the first thing is the opposing parties. Yesterday I have told you that the person himself cannot claim relief against his own self. A person cannot fight against his own self, himself. So, what is the requirement? At least there should be the two parties, meaning thereby opposing parties should be there. First essential ingredient is that the opposing parties. Second essential ingredient is that subject matter in dispute. Unless and until there is the subject matter in dispute, how we can fight? One gentleman wants the divorce and he is not get married. No, there is no subject matter in dispute. If there is a marriage, marriage is the subject matter and dispute is that he is not happy with his wife. Third thing is the cause of action. Unless and until there is the cause of action to institute the suit, your suit will not be liable. And the fourth thing is the relief's claim. There should be the prayers. So, in detail, we have to discuss the concept of the institution of the suit in section 26 and order 4. Prior to it, for institution of the suit, one of the most important thing which is required, that is the parties to the suit. Order 1 deals with regards to the parties to the suit. Order 2 deals with regards to the frame of suit. Order 3 deals with regards to the recognized agents and the pleaders. Order 4 deals with regards to the institution of suit. Now, we will firstly just see the order 4, what the order 4 reads, what is the contents of the order 4. In order 4, there are only 2 rules. Order 4 heading is the institution of suits, and it is stated rule 1 states suits to be commenced by plaint. Every suit shall be instituted by presenting a plaint in the duplicate to the court or such officer as it appoints in this behalf. 2. Every plaint shall comply with the rules contained in Order 6, that is the pleadings generally, and Order 6 and 7, 7 is the plaint, so far as they are applicable. So, for the institution of the suit, whatever the rules contained in the Order 6 and the 7s are applicable. 3. The plaint shall not be deemed to be duly instituted unless it complies with the requirements specified in subrule 1 and 2. Meaning thereby, for the commencement of the suit to be commenced by plaint. Unless you draft the plaint, unless you read the provisions of Order 6 pleadings generally, you can't draft the plaint. Unless you decide the cause of action, unless you decide who are the parties to the who should be the parties to the suit, you can't draft the plaint. Who may draft the plaint? Unless the person is having legal knowledge. Therefore, Order 3 is there. How to draft the plaint? Which cause of action shall be included? Which cause of action shall not be included? Therefore, the Order 2 is there, frame of suit. We will just read the rule 2 of the Order 4. Register of suit. The court shall cause the particulars of every suit to be entered in a book to be kept for the purpose and called the Register of Civil Suit. Such entries shall be numbered in every year according to the order in which the plaints are admitted. After duly presentation of the plaint, if he complies with the provisions of Order 6 and Order 7, then it will be registered as a suit, and in the register of suit commences every year. It will commences from the 1st January English calendar. One number will be registered, maybe the special civil suit or the regular civil suit. It will commences from the 1st January, and there will be the register in the suits, and now it will be the online. So this is the Order 4, and Section 26 deals with regards to the institution of the suit. But I have already told you, for the institution of the suit, 4 things are important. And the first thing is the opposing parties, and Order 1 deals with regards to the parties to the suits. Who may be the parties to the suit? Probably in tomorrow's lecture, we will discuss from Order 1 to Order 10, what are the proceedings, what are the stages with regards to it, pleadings, who may be the parties to the suit, what is the concept of frame of suit, why there is the requirement of the recognized agents and the pleaders according to the Order 3. After the institution of the suit, what is the first stage after if the suit has been duly instituted, according to the Order 5 and Section 27 to 32, court is required to issue summonses to the defendants, and Order 5 deals with regards to the service of issue and service of summonses. Another fact is that Order 6, 7 and Order 8 deals with regards to the pleadings of plaint and the written statement, set off and the counter plea. So in tomorrow's lecture, we will start to begin from the Order 1 of the Code of Civil Procedure. In today's lecture, we have discussed with regards to the jurisdiction aspect of the civil code, starting from Section 9 to Section 21A, objection to the jurisdiction, and from Section 22 to 25, provisions with regards to the powers of the court to transfer the suits from one court to another court. Then after we have discussed the Section 26 and Order 4 deals with regards to the institution of suits, in the institution of suit, every suit to be instituted, it will commences by the presentation of the plaint, and for the preparation of the plaint, we have request to go through the order 6 pleadings generally. For the that purposes or for the institution of the suit, 4 things are essential. Opposing parties should be there, subject matter in dispute should be there, the cause of action to the subject matter should be there, and the reliefs should be there. So in tomorrow's lecture, we will discuss the remaining part.
Thank you, sir. Dear friends, first and foremost, I express our sincere gratitude to Shri Sandeep Munde sir for delivering such a lucid, insightful, and practical session on the Civil Procedure Code.